Hello, everyone. I guess we could begin. Hang on. Hold on. Wait, what happened here? Okay. So, welcome, everyone, and good evening. Tonight, we're going to be talking about internal relations, defense, and the external affairs power. Before we begin tonight's session, would anyone have anything to say? Any comments, any questions that you might have? You're all good?
Hi, Manjo. I just want to ask you about the submitting the online discussion. Do I do it like last year? You write down all the dates that you took part in the tutorial and then put up 5 answers, or is it either or both of those? Put up the dates and the 5 questions?
No, it's actually and or. So if you, for example, participated in the tutorials 5 times, if you actually engaged orally, then you don't even have to submit any answers for the Moodle discussion questions. So every single oral participation in our tutorials counts as one answer to a discussion question. So if...
No, but we still have to submit a document, right? A Word document and put down the dates. Is that right?
Yeah. All you need to do is to indicate the dates that you orally participated at our tutorials. Nothing more. So you don't have to put the answer to any question nor what you actually said during the tutorial. But you need to submit that Word document in Moodle. Okay, any other questions? None?
Hi, Manjo, it's Tiffany.
Tiffany, yes.
I didn't obviously I can go back through the videos, but I didn't make a note of when I participated and when I didn't. But also I know you were quite strict with it, saying that, you have to kind of actively participate in the tutorial. So is it better if we've answered questions as well to just to submit our answers and then also put the dates that we've contributed? So we're kind of doubling up.
Yeah, you could.
Check we're hitting it all.
There's nothing wrong with that. When I say actively participate at the tutorials, it actually means that, for as long as, not something like this, you're simply asking a question, but if in the course of the tutorials, I ask a question, and then you actually participate by giving an answer or giving a comment, then that's an oral participation that counts. What doesn't count would be if you just chatted in the chat box. But if you want to feel safe, then you can do both, but you don't have to.
Yeah, so just to clarify, so if we submit our 5 answers and then put the dates that we participated, we're good. We're going to get them those 10 marks.
Let's clarify.
Between the 2.
No, let's clarify. In relation to the Zoom tutorials, you will definitely get 2 points each time that you orally participate. So that's automatic. As soon as you orally participate, you get 2 points for that particular session. But it is not true for the group discussion answers, because I need to assess the quality of the answers. In other words, if the answers, for example, don't meet the word count, or they're not of a good quality, no. I don't think I said good quality. For as long as it is a genuine attempt at answering the question, even if it's wrong, the student is going to get the full 2 marks or 2 points, whatever is the, however that is labeled. But so certainly a student who does not meet the word count or does not come up with a legitimate attempt or a genuine attempt at answering the question, because all the student does, for example, is copy and paste notes, or the student has not really responded properly to the question. So for example, if the question is about separation of powers and the student talks about, treaty powers, so it's a totally wrong answer, then that won't be considered a genuine attempt. So in that case, I will mark down the answer. But as I said, in relation to the Zoom tutorials, every time you participate orally, you always get the full 2 marks, regardless of the quality of your answer or oral participation. Now, I have a...
Okay, one last thing.
Sure.
Everyone's going to hate me. I'm so sorry. But, okay, so let's say we participated, let's say 3 times, not 5.
Yes.
Would we then submit because we think that like it's been active participation, would we then, can we still then submit the 5 answers that we've done, and then you will give us the marks based on the best, or will you only read like say the first 2 out of 5, or like how will you work that out?
You'll be safe. I mean, I'm quite liberal. Let's just say that I'm very liberal as far as the group discussion is concerned. It's actually a way for me to help students pass the course. So in a sense, it's a give. Okay, so it's almost a give. I mean, if it were golf, we call it a give. So it's a way for students to get extra marks so that they pass the course or they go for a high distinction. So that's the beauty. So I'm not very strict as far as the group discussion is concerned. For as long as I know, there has been a genuine attempt, either at engagement during the tutorials or in the group discussion questions. Now,
perfect, thank you.
Yep, no worries. I've got a question here from Karen about the due date. Karen, yeah, from Brad, it's kind of a mulligan. So I play golf as well, although not that good. I only got a 27 as a handicap, but I do play golf. So there is a question from Brad, when the document is due. I can't really remember, Brad. It's in the Moodle site, so I won't be able to answer that. Oh, so there's an answer from Karen. It's due on the 29th. That's next week at 8 p.m. So I can't remember the exact due date. You're going to have to look it up in the either in the course profile or in Moodle. Okay, so let's begin. So the internal relations power of the Commonwealth, as we will see, has again been a way by which the Commonwealth power has tried to encroach into subject matters that would have belonged exclusively to the states. Because remember, as we said, the Commonwealth Parliament can only legislate in relation to those heads of power which either have been expressly or impliedly provided in the Constitution, particularly in relation to Section 51, so that all the other subject matters are meant to belong and vest exclusively to the state parliaments. So internal relations, the internal relations power of the Commonwealth has been a way by which the Commonwealth Parliament has kind of encroached into the subject matters which would have belonged to the states, as well as the use of the defense power as well. Now, I'd like to flag at this point that you will probably notice that when the Commonwealth Parliament uses the internal relations power or the defense power, there is, in many of the cases in the High Court, what has actually happened was that there was an attempt on the part of the Commonwealth Parliament to affect constitutional rights and freedoms. Not always, but it often affects constitutional rights and freedoms, particularly, for example, if you look at the cases of Thomas versus Mowbray and the case of Polyukovich versus the Commonwealth. And I would like to highlight particularly the case of Polyukovich because it's a topic that I typically ask a question about during the final assessment, because it's important, especially because of its implication on constitutional rights and freedoms. Because remember, in Australia, we don't have a Bill of Rights. Unlike, for example, the US Constitution, which has a Bill of Rights, there is none in Australia. And so that and that's a topic we're covering next week. So that when you speak of constitutional rights and freedoms, a lot of it has actually been based on the recognition by the courts. Although there are some constitutional rights and freedoms which are provided in the Constitution. For example, the issue about expropriation and just cause, or the issues about religion. But in general, there is no equivalent Bill of Rights in the Australian Constitution. And so therefore, it's interesting in the sense that because there is no entrenched Bill of Rights, oftentimes it's difficult to argue that a law passed by the Commonwealth Parliament that affects constitutional rights and freedoms. For example, the power to just search and seize properties that belong to to Australian citizens, or probably the power to enter into homes or do surveillance of individuals. There is no equivalent, as we will see next week. There is no equivalent, because there's no equivalent Bill of Rights. It's quite possible for the Commonwealth Parliament's powers to legislate in that regard to more often than not be given due recognition by the High Court as being valid. And so, the Commonwealth Parliament does that either using the defense powers or the external affairs powers, as we will see. So that makes it this topic quite important because it directly affects citizens. So unlike, for example, when you talk about the separation of powers, or you talk about industrial relations between the Commonwealth and the states, it doesn't directly affect us. It doesn't directly affect you as citizens. But the power of the Commonwealth Parliament to legislate in relation to internal relations and in relation to defense, these are powers of the Commonwealth Parliament that directly affect citizens of Australia. And to me, therefore, it is a very important topic for us. So tonight, in terms of the key outcomes, after studying this topic, you should be able to discuss and explain how the Commonwealth Parliament, by using its international powers, particularly relating to defense and external affairs, is able to expand its reach into areas usually associated with state parliamentary powers. And then you should also be able to discuss and explain how the Commonwealth Parliament, by using its external affairs, is able to legislate on matters outside of and external to Australia. So let's begin. Question one for this week, or discussion question 45, I believe. So to protect Australia against threats of terrorism, and obviously, the threats of terrorism are quite salient at this time because of what has been happening in the US just yesterday. I hope you're aware of that, the bombing in Chelsea, which is in New York. So, and of course, you had the Lint Cafe domestic terrorism incident, which happened last year. So, to protect Australia against threats of terrorism, the Commonwealth Parliament passed the Border Protection Security Act, Commonwealth, giving wider powers to the Australian Security Intelligence Organisation to gather information and conduct surveillance of Australian citizens and visitors, including the power to intercept and record phone and email communications of all persons in Australia. So imagine if there were that kind of legislation, which I think was at some point being discussed in the Parliament. Now, Julian Lazard, an Australian citizen, seeks to challenge the law on the ground that it cannot be justified under the defense powers of the Commonwealth Parliament. Advise Lazard on whether his legal challenge is likely to prosper. And I remember, by the way, last year, I think, that the Commonwealth Police did a lot of stop and frisk activity in Sydney, was it? Where they were just stopping people at random to check if, I don't know, they may have been about to commit a crime. So, but that's something about constitutional rights and freedom. But assuming that there was such kind of law, and in particular, if there were this specific legislation, and Lazard is seeking to question the validity of that law, and you are the solicitor, what would you advise? Any volunteers?
Can I volunteer, Manjo? Jessica here.
Thank you, Jessica. Yes, go ahead, please.
Okay, great. So I've got the issue as, is this act valid under a head of power under the Constitution?
Okay, hang on. Wait. Okay, go on.
Okay, and the rule that I identified was section 51.
Sorry, Jessica, can I just stop you there, if it's all right?
Yeah, sure.
Okay, I'm stopping you there mainly because of the issue of the way you identify the legal issue. And apologies, because I had to interrupt you. The reason I'm doing it is because I've been marking a number of the legal memorandums, and it would appear to me that a number of students have had difficulty actually identifying the legal issue. And so you've attempted to define the legal issue right now by, you were kind of saying if it was valid under one of the heads of power of the Australian Constitution. Wasn't that what you said? That is just a bit too broad. Okay. So you need, this early, you need to be able to clearly identify what the legal issue is. So you're going to have to say that if this law is valid under whatever, the defense power or the treaty affairs power of the Australian Commonwealth Parliament, the reason why it has to be specific is because what we need to remember is that the moment you identify the legal issue, it then allows you to identify what the relevant legal rules are or what the relevant legal principles are. So if you identify a very general legal issue, the question then is, what legal rules exactly are you going to be citing? So in other words, the legal issue, the identification of the legal issue allows you to delimit and specifically identify the relevant legal rules and legal principles. So the legal issue is very crucial. It's like you cannot attempt to come up with a conclusion without knowing what the legal issue is. You first need, in other words, to know what the question is, what the problem is. And that problem has to be identified by knowing what the specific legal issue is. So it cannot be general, it cannot be broad. And that has been the problem for most of, so I had to tell this because we're now in week 10. And that has been the problem for a number of students because a lot their legal issue is just too broad. And in that case, because it is too broad, it is too general, it's difficult for me to see the connection between the legal issue that they've identified and the legal rule that they've cited. It's like, okay, where is this legal rule coming from? Because, you haven't told me what the legal issue is. So the legal issue actually is a crucial feature of every answer because your answer, therefore, revolves around the legal issue. Okay?
Yeah.
In other words, you can't talk of anything else that has nothing to do with the legal issue. That's why it's very crucial. Okay, so having said that as a suggestion, and I apologize for interrupting you there, but I needed to do this because we're in week 10, and I'm really hoping that we now get into the habit of trying to be more specific in identifying the legal issue. So having said that, yes.
So could I rephrase the issue as, can the Commonwealth Parliament make the above laws under the defence powers under the Constitution?
Yes, that would be better. Very
okay.
Good. Go ahead.
Excellent. So then I've identified the rule as Section 51, subsection 6 of the Constitution, provides the Parliament with powers to make laws with respect to the defence of the Commonwealth. And then I also identified the rule in Australian Communist Party versus Commonwealth, where Justice Fulliger identified two aspects to the defence powers. The primary aspect of the defence power empowers lawmaking during times of war and peace, as long as the law has as their direct and immediate object the defence of the Commonwealth and the states. In wartime, there's a secondary aspect where this power can be used for extensive and detailed control of the community in relation not only to war service and war supplies, but to other matters such as social conditions. So it covers matters that would not be seen in peacetime as having any connection with defence. Then I've applied the above those two rules. So in this case, the facts say that the above action of gathering information and the conduct of surveillance of all Australian citizens and visitors is to protect Australia against threats of terrorism. So I would argue that that its direct and immediate object is not a defence, is not defence. So if the above law was made during wartime, it could be considered permissible under the secondary aspect, as it could be seen to regulate social conditions in connection with defence. However, given that Australia is currently in peacetime at present, the above law would be invalid under the defence powers, concluding that Lasard's challenge would unlikely prosper.
Okay, that would make an HD answer. Very good, Jessica. That's
Okay.
the answer. I mean, high distinction. So as long as you nail the legal issue correctly. So that's a correct answer. Let me just ask a question though. Why would it be invalid if you follow the expansionary consequences of the engineer's case? We know from the previous discussions we've had that for as long as the legislation of the Commonwealth Parliament can draw a sufficient link to a head of power, then that law is valid. And in this case, it's quite clear that this is about the defense of the Commonwealth. So why would it be invalid? That's my question there. Karen, we'll get Karen, I saw her hand, and then if somebody else wants to speak, you'll be next, whoever that might be. Then Nicholas. Yes, Karen.
I wondered if that was because of the Thomas and Mowbray decision, 2007, in which they took a wide view of defence power because of the international community's concern over terrorism, and that brought in more of the external power rather than the defence power. Okay.
So in your case, Karen, what you're actually doing is you're providing a contrary opinion to that which has been given by Jessica, using Thomas versus Mowbray. Okay. I was hoping to give Jessica a chance to answer, but in a short while, let me listen to, who was that before? I mean, after Karen, was it Nicholas? Nicholas, did you?
Sorry, I'm probably going to be interrupted by a toddler. I'm babysitting.
That's all right. That's all right. Go ahead. Not a problem.
I just very quickly, when you look at Thomas and Mowbray, I would consider that to be, again, still a direct. What's the wording? It's direct and immediate effect, direct and immediate object, because it is having a specific object on whatever his name was, Jihad Jack, at the time. Whereas if you look at this is an indiscriminate power that looks at the whole of Australia and doesn't have an immediate object. So I would still go with the original answer and say that it's unlawful.
Okay, thank you. So you mentioned a criterion, which is the need for the legislation to have a direct and immediate object. I saw Tiffany raising her hand, I believe. Yes, Tiffany. Yeah,
okay, so...
Thank you, Nicholas.
Maybe I misunderstood. I thought you said what's the difference between this, because of the engineer's case, it was expansionary under the heads of power. If they just chucked it in under one of them, under 51, then you're all good. But what was the difference here? And I thought that the difference here was that with this section in regards to defence, it's got a clear purpose. And so the purpose of the law has to therefore be for defence. So with all the other heads of power under 51, there isn't that clear purpose. Is that right?
That's what you said. So are you saying that in relation to the defence power, there is a requirement for...
Yeah, so there's, I think it was something Coleman case, and there had to be, it was held that there was a purposive approach. I'm just trying to pull this off the top of my head from what I remember. Sorry. That there was that requirement that the legislation actually had to be for the purpose of defence, where it could be broader under the other heads.
Well done. Okay. You're correct. So Jessica, Nicholas, and Tiffany would actually be correct. So among all the heads of power, where there is no requirement of purposiveness, the only head of power where there is a requirement that, where there is a purposive test being imposed by the High Court, is actually in relation to the defense power of the Commonwealth Parliament. So that if there is a legislation which is meant to be in relation to the defense of the Commonwealth and of the states, then the validity of that legislation will be examined on the basis of the purposive test of whether or not the legislation is in fact moving towards the purpose of defending the Commonwealth and the states. So as correctly pointed out, there is the case of Stenhouse versus Coleman, and where the High Court has pointed out that there is a purposive test, which is recognized as a limitation of the exercise of the defense power of the Commonwealth under Section 51, subsection 6 of the Australian Constitution. Now, as important, because there is a purposive test, so unlike, as we said, as far, and I'm trying to emphasize this because I enjoy asking this question in the final assessment. To those who study, it's easy to answer. But to those who don't, and they don't listen to the tutorials, they're likely going to miss out on it. So having given that as a, what was that? An important cue. Okay, so having said that, apart from the purposive test, there is also a question of reasonableness and proportionality. So while it is true that it might be possible for the Commonwealth Parliament to say that, that's right, Brad, it's a hint. So while it might be possible for the Commonwealth Parliament to say that it is directed towards the purpose of defending the Commonwealth and the states, there is a requirement of proportionality and reasonableness, so that whatever is the legislation, the measures in that legislation must be reasonable in terms of the way that it affects and curtails freedoms and liberties of the citizens. So there's a question of, are they reasonable, and are they proportionate to the purpose that it seeks to achieve? And that is because it is already recognized in Australia as well, in the case especially of Australian Capital Television Proprietary Limited versus Commonwealth, that we live in a representative parliamentary democracy where, notwithstanding the absence of a Bill of Rights, there are certain constitutional rights and freedoms that are in fact impliedly recognized in a representative parliamentary democracy. And the court, specifically in the case of Adelaide Company of Jehovah's Witnesses versus the Commonwealth, again emphasized that it would not tolerate legislation which is arbitrary, capricious, and oppressive. Okay, so that's crucial that we need to remember, so that even if we might think that the power of the Commonwealth Parliament under the defense power is quite broad and expansive, according to the expansionary doctrine, in fact, this is the only head of power where the High Court has clearly seen the need to recognize a limitation in terms of purposiveness, reasonableness, and proportionality. Okay, so the answer of Jessica was correct, as well as pointed out earlier by Tiffany and Nicholas. Thank you, and I've seen the comment here of B. Thank you, B. So, yep, that's correct. So the answer of B as well is correct. Okay, moving on. Question?
Just one thing, Manjo. Scott,
Scott, yes.
That reasonableness and proportionality, was that based on founded in Adelaide Company of Jehovah's Witnesses case?
Yes, as well, among others, yes. Okay.
Can I ask a question, Manjo?
Brad, go ahead, yes.
Maybe you can just give some clarity as to Section 51, subsection 5,
yes,
in regards to the powers in respect of postal, telegraphic, telephonic, and all other like services. So I understand what you're saying about the reasonableness. It would be what's within the actual legislation.
Yes.
So the question I'm asking is, how are they not then able to enact to bring about an act in regards to the telecommunications under the existing constitution? So,
I see your point. That's a very good point, Brad. So the argument of Brad is, what if the Commonwealth Parliament passes a law and it does not rely on the defense power? In this case, for example, as correctly pointed out by Brad, it could be argued that the Commonwealth Parliament has the power to pass this legislation in relation to Section 51, subsection 5, which particularly talks about postal, telegraphic, telephonic, and other like services. Very good point. Fantastic, Brad. Vanessa, raise your hand. What do you think, Vanessa? Are we going to respond to what Brad said?
I actually had a separate question, so you can come back to me tonight.
Okay. Yep. Would anyone wish to answer Brad's question? Scott?
Yeah, possibly. I think it probably just relies on exactly what you were saying before. Even though the Adelaide Company and Jehovah's Witnesses, it was dealing with the defence power, I think the reasonableness and proportionality aspect of that case would still apply, in that it would not be considered reasonable and proportionate for the government to be able to listen on to every private phone call made by every Australian citizen. So I don't think, even though the power is contained in Section 5 in relation to telephones, I don't think that it would be constitutional, because it would still fly in the face of that decision being reasonable and proportionate. I think it may be different if the legislation was worded differently, in that there was sufficient evidence to target a certain individual, but as a blanket for every Australian citizen, I don't think it'd be reasonable and proportionate as per the Australian Company of Jehovah's Witnesses.
Fantastic. So the reason why, and Scott is definitely correct, the reason why the same rules would hold is simply because there are certain implied rights and freedoms on the part of Australian citizens that are recognized by the High Court as being implied in the Constitution and as being implied in an Australian parliamentary democracy. And because such a law therefore infringes and affects Australian rights and freedoms, the same limitations would apply. Notwithstanding the fact that it is Section 51, subsection 5, which should have been invoked by the Commonwealth Parliament. Yes, Brad.
So, Manjo, the question I have is, it may be valid to bring about such legislation, but the tests in regards to the propositiveness, reasonableness, and proportionality, would that be then based on the context of the legislation?
Let's make a distinction, because the specific example we have is that it is a legislation which relies, in the example you gave, on Section 51, subsection 5, but it affects the constitutional rights and freedoms of people. And it is because of that effect on constitutional rights and freedoms where you have to raise the question of reasonableness and proportionality. On the other hand, had it been a general law which simply legislated about, telephony or telegraphs or the use of phones, perhaps the way that it regulates businesses and the way that they would operate their business, therefore it doesn't affect constitutional rights and freedoms, then certainly in that case, the expansionary consequences of the engineer's case will apply. Okay. But the moment certain constitutional rights and freedoms are affected, as in this case, it becomes altogether different, because in a parliamentary democracy, there is a requirement that there are certain constitutional rights and freedoms that must be recognized by the Commonwealth Parliament, and the High Court will not allow those constitutional rights and freedoms to be arbitrarily, oppressively, and capriciously affected by the or infringed by the Commonwealth Parliament. So there goes the distinction there.
Okay, excellent. Thank you.
Very good question. As pointed out by B, same answer regardless of heads of power, mainly because of the implied rights and freedoms, which can be found in the next chapter. Very good. Okay. Next question. So again, you can see how crucial that is, because as given in the example here by in the chat, and I'm looking at it. Sorry, I couldn't read all what's going on in the chat. But as Brad pointed out, in Melbourne at one time, at restaurants, the Commonwealth Police were doing visa checks. Was it just in relation to visa checks? But in the process of doing visa checks, they could end up accosting and stopping almost anyone. Because how are they to know whether you're an Australian citizen or not? Correct? I mean, you're not going to be putting a sign on yourself that you're an Aussie citizen. And even if you were, they wouldn't stop the Commonwealth Police from stopping you. And so they use the border force. Okay. Thank you, Carl. Okay, so discussion question 46, question 2 for this week. The Commonwealth Parliament passed the Border Security Act, Commonwealth, making it an offence for an Australian citizen to join, associate with, or provide assistance to named terrorist organizations abroad. Alan Lambert, an Australian citizen, was charged under the Act for receiving military training from the Jemaah Islamiyah, a named terrorist organization, at a camp in Syria. Lambert seeks to challenge the law on the ground that he cannot be held criminally liable for an act that occurred outside of Australia. Interesting. Advise Lambert on whether his legal challenge is likely to prosper. Because come to think of it, imagine if you were doing something, say, in Indonesia, or you were doing something in China, and the Commonwealth Parliament would then pass a legislation that could probably criminalize behavior occurring abroad. Okay, what do you think?
Hi, Manjo. Have you got me?
That's Anthony, is it?
Yeah, sorry, I've had some problems with my microphone.
Sorry, Anthony, I need to get your last name.
Knowlton.
Nelson, okay, thank you.
Sorry, Knowlton with a K. I'll put it in the chat so you got it.
Okay, yes. If you could just, in the chat box, you mean?
Yeah.
Okay, thank you. Go ahead.
So I saw the issue is under the Defence and External Affairs powers in the Constitution, can the Commonwealth form legislation regarding national security that applies extraterritorially?
Okay. Yes.
Within the External Affairs...
I just wanted to say that that's quite specific. So that's good. So because you cited external affairs and defense power, I think, and extraterritoriality, we know already what the relevant rules likely are that will inform the legal issue that you've identified. So that's very good. Yes.
Yeah, I took the hint from the answer to the last question and adapted it.
Very good. That's very good. Very good. Go on.
Under Section 51, subsection 29, the External Affairs power, the government is able to make legislation that will apply internationally. And in a sense, I saw the issue here partially analogous with Thomas v. Mowbray, where Thomas had trained with Al-Qaeda in Afghanistan, and the High Court ruled that the control order that was applied under that was supported by the defence power. So in this case, I would say that despite the fact that the training occurred overseas, that Lambert's still bound by that legislation by being an Australian citizen.
Very good. Because you cited, in this case, the basis for the Commonwealth Parliament's power to legislate on the defence power, you might be missing something then. If you cite the defence power, what else is it that you need to be able to cite? Did I see, sorry, Scott's hand being raised? Yes, Scott.
Yes, Manjo, I think you probably have to cite the external powers as well in that Playkovich and Commonwealth, where they found that it was constitutional for Australia to legislate on matters that were external to Australia in regards to war crimes committed in Europe. So whilst we're not saying he's committed war crimes, he's committed a crime which is an offence against Australian law as by this externally, and Polikovic and Commonwealth give the authority for that.
Very good. Thank you, Scott. So Polikovic versus Commonwealth would be the relevant law. I mean, the relevant case that will be cited here. So thank you very much, Scott. You're correct on that. I'd like to go back, though, to what Anthony was saying. So, Anthony, the moment what is being then cited is the defense power, what is it that then needs to be established? Is it sufficient to argue that this specific legislation, for example, has for its purpose the defense of the Commonwealth and the states? Is that sufficient?
Well, there's limitations to that power given whether the nation is at war or at peace. And this goes back to a comment I made in the chat a little bit earlier, that the definition of whether we're at war or peace is a bit subjective.
Yes.
Because of there is a threat from an enemy combatant that cannot be defined. And however, there's no existential threat like we faced, for example, during World War II. So I wasn't sure whether there was a legal basis or definition of what would declare Australia being at war or peace. And that was the question I asked in chat.
Okay. So the question I wanted to raise was, if you cite the defense power of the Commonwealth, what else must you establish? Yes, Scott.
Yeah, is this back where we had to say with Stenhouse and Coleman, where it's a pervasive test that you have to show that it was defence power, it's not just a factual link between the defence and the law, that there's some purpose for it. And obviously then again, Adelaide Company and Jehovah's Witness, it must be reasonable and proportionate.
That's right. Very good. So the moment you cite the defense power, and as we can see in the case of Thomas versus Mowbray, the defense power is not limited specifically just to times of war. It can be done in times of peace, because issues of terrorism would actually relate to the defense of the Commonwealth in the case of Thomas versus Mowbray. But the moment you cite the defense of the Commonwealth as your basis for this type of legislation, it is crucial for you, therefore, to be able to argue that there is a reasonable and purposive and a proportionate basis for that specific type of legislation. Now, on the other hand, if, as pointed out, you cite Polikovic versus Commonwealth, especially in this particular case, because what actually has occurred is that it's really a question of making it an offense for an Australian citizen to get involved in activity abroad. The more relevant head of legislation should actually be the external affairs power, because what is sought to be done by the Commonwealth Parliament is actually to regulate and control behavior by either an Australian citizen or an Australian resident for an act which occurs outside the border of Australia. Generally under international law, or even under basic criminal law, because of the principle of territoriality, the jurisdiction and the powers of a sovereign nation do not extend beyond or outside of its borders. So in fact, the tricky thing here is, what if it were legal abroad? How can you criminalize behavior that is legal abroad in Australia? So let's say, the Australian Parliament, for example, may criminalize polygamy. So is it a crime in Australia? I'm not really sure. But let's assume, just as an example, that polygamy or multiple marriages entered into by an Australian citizen is outlawed and is a criminal activity. And let's assume that a person engages in polygamous marriages, say in Libya. It is legal in Libya, but then it becomes criminal in Australia. Would that be legal? That's just an example. Did Nicholas raise his hand? Yes, Nicholas.
Yeah, I was just thinking about that one. I'd read Polikovic a lot from my memorandum. There was the whole theme running through that it's got to be of a concern to Australia, and there was a thing on touch and concern Australia that I think Tui said in his decision. So I think something like the marriage thing, it'd be a long blow to draw to say that somebody getting married to a second wife in another country affects the affairs of Australia, whereas something like somebody joining a terrorist organisation you can see that Australia has an interest and it is touched and concerned by it. Although I don't think, anyway, I won't go on too long.
I like the answers that I'm hearing tonight. Well done. So it means, at least with the people who consistently be joining the Zoom tutorials, it certainly means that you've learned a lot about constitutional law. So well done. That's the correct answer there. So again, it suggests to you, well, for those who'll be watching the video recording anyway, Polukovich versus Commonwealth is an important case that you would need to read. So thank you. Well done.
Manjo?
Brad?
Yeah, I just want to know that, I mean, the basis, the fact that he does a criminal act overseas, or what we consider to be criminal, the basis of this type of act is to protect the border and to restrict his entry back into Australia.
Possibly, yes.
Yeah, so, okay, that's right. So I'm sort of looking at it going, well, yeah, if he did it over there and he stayed there, well, our powers aren't going to reach over to Syria. It's when he comes back to Australia that we are then enabling this act to then take him into custody to protect the border and his re-entry into society.
That's right. But again, Brad, you're limiting this legislation to the idea that it has been passed for the purpose of protecting the borders of Australia. I mean, it could be, but again, it could simply be that Australia feels that this is a behavior that needs to be criminalized, regardless of its impact on Australia's borders. So in other words, it can criminalize pedophilia abroad, or even bestiality abroad, committed by an Australian citizen. Nothing to do with defense, in other words.
Yeah.
The question then becomes, would that be valid? The answer is yes. Because it is to Australia's interest to perhaps to safeguard morality, or to minimize behavior of Australian citizens that have a very negative effect on other peoples. So a legislation that criminalizes pedophilia, and we have a legislation in Australia for that would be authorized by Polukovich versus Commonwealth and not by the defense power. Yes, Scott.
Yeah, I was just going to add to that, Manjo, that it may just be for the interests of Australia, like that pedophilia. We have we're members of international treaties in regards to the child sex trade and that sort of thing. So we want to instruct and limit behaviours of our citizens abroad to make sure that this is the behaviour that we tolerate here. And if you go on the sex tour to overseas countries or whatever, you will be held liable when you come back. So you better not do it. Rather than just a defence power, it can be just a behaviour instructing type legislation.
Very good. Thank you, Scott. Thank you. That's correct. Very good. B, you raised your hand.
Yes. Sorry. I think I totally agree with what Nicholas said about the legislation needing to, somehow involve Australia. But I thought what it said that it didn't have to. I thought Polukovich actually said that even though the legislation did not have any connection with Australia, it could still be valid.
Yes, but that's because in the case of Polukovich versus Commonwealth, it is an exceptional circumstance because it concerned heinous crimes, affecting crimes against humanity. So in other words, although it did not have a direct impact on Australia, because in the case of Thomas versus Mowbray, there is now a requirement that we must be able to point to an effect on Australia's interests in relation to these types of legislation. Polukovich is a distinct case because of the fact that it involved genocide and heinous crimes, which are crimes against humanity, which therefore affects all civilized nations, including Australia, even if Australia was not directly affected. So that is a distinct circumstance. Thank you, but thank you very much, B. You're correct. Thanks for raising that. I think I saw the hand of Vanessa being raised. Vanessa.
Manjo, this might be slightly off topic because we are doing constitutional law, but another way or another point that jumped out in my mind, and this may be off topic slightly, is where this evidence has come from that he actually received the training. Like, where did the government obtain this evidence to establish it? Now, I know that's a slightly different argument to the constitutional validity of the legislation, but at the end of the day, if Lambert was my client, you would want to get him off whichever way you could. So if I couldn't find a constitutional argument, perhaps there would have to be something in the legislation to define what is the military training and how to substantiate that he received it. Now, as I said, this may be off topic, but if this was an exam question and I mentioned something like that, would that be going off topic, if that makes sense?
That would be going off topic.
Okay, good. I'm glad I asked.
Yeah, but as a lawyer, you certainly should do that. That's right, but that's a good point. So what I'm saying here, Vanessa, what I'm saying now is that you're able to draw the connection between constitutional law and other areas of law. So now you're touching on the rules of evidence, so that's good. But for the purpose of the final assessment in constitutional law, we need to limit our discussion to just constitutional principles and nothing about evidence or nothing about criminal law, or not even about public international law.
Good. Thank you very much.
Thank you. Now, question 47. In 2013, Australia ratified the International Convention to Address Climate Change, a multilateral treaty signed by more than 40 nations. To implement the treaty, the Commonwealth Parliament passed the Climate Change Act, Commonwealth, that imposed rules and regulations on farming and agriculture practices. XYZ Proprietary Limited, an agricultural company in Queensland, seeks to challenge the legality of a fine imposed against it under the Act. The company argues that the Commonwealth Parliament has no power over farming and agriculture. Advise XYZ Proprietary Limited on whether its legal challenge is likely to prosper. Volunteers? Can I get a volunteer? Volunteer. So from B, I'll just read the issue she says. The Act regulating farming and agriculture practice, a constitutionally valid act. We're missing something there. Too broad. Too broad. Comments?
How about is the Commonwealth Parliament able to pass an act regulating farming and agricultural practice?
On the basis of?
On the basis of, actually I have it as under section 51.1 and section 51.29.
Very good. So that's what's the missing element there. Because otherwise, if you don't cite the specific heads of power, then you'll end up discussing farming and agricultural practice, which obviously the Commonwealth Parliament has no power to legislate on. But if you then cite section 51.1, and especially if you cite the external affairs power, then we know what the relevant rules and principles are likely going to be when you discuss your answer. Okay, so can we get a volunteer to answer question 47? Volunteer?
Hi, can I give it a go?
Oluwayumi. Yes, go ahead, please.
I think they can. I support this with the Commonwealth and Tasmanian case, where the court says that the scope of, because it encompasses not just Australia, and they have more than, they have about 40 nations that signs the treaty. Then that gives Australia the power under section 51, I don't know, XX1X or high X, sorry, I don't know what number that is, that then it gives them the power to use that authority domestically, even though the parliament does not have power over agriculture when it comes to states, but when you put it under the external affair power of the constitution, they could still use it. That is not limited to just only external, as long as there is a treaty that Australia actually agreed to.
That's right. So as part of Oluwayumi here, what seems interesting is that on the basis of a treaty which is meant to govern activities abroad because it's external affairs, and yet the activity that's being regulated is domestic. And yet, as pointed out by Oluwayumi, that is valid under the external affairs power of the Commonwealth. The question I have though, Oluwayumi, is that that specific legislation does not actually address the issue of climate change. That's about farming and agriculture. How can that be valid?
Because it was talking about the heritage things that Australia signed with international world. I don't know if it is US.
You're talking about the Tasmanian Dam case.
Yeah, I'm talking about the Tasmanian Dam case. And
in relation to the problem here, how can you justify the use of the external affairs power if the specific law is about farming and agriculture, which is not about climate change? And let's just focus on external affairs power for now. Let's not focus on section 51.1, not on international commerce. How can that be valid if this specific legislation seems to have nothing to do with climate change? Because it talks about farming and agricultural practices. That's my question.
Okay, the similarity is the fact that the treaty about world heritage is actually not domestic, it's international, that Australia signed, that agreed on. That is what the Tasmanian, that's what the court was saying, that they actually agreed to this treaty so they could operate it domestically. And the same goes with the climate change, because they agree with it internationally, then they could then use it domestically because that's what they agreed on.
Okay, it's kind of off tangent what I'm going to say now, but I just need to correct something there, okay? So in Australia, as we will learn in public international law later on, the mere fact that the executive is always the executive which enters into treaties, okay? The mere fact that the executive enters into a treaty does not represent a duty on the part of the Commonwealth to actually pass legislation affirming or containing whatever is in the treaty. So that we don't have what is known as the incorporation principle. So the mere fact that there is a treaty doesn't mean that the Commonwealth Parliament is then obliged either under Australian law or under public international law to pass a domestic legislation that is in conformity with a treaty. That is not the case. So there might be a treaty, the Commonwealth, and that treaty does not represent law in Australia until the Commonwealth Parliament passes a law incorporating the treaty provisions. So let's begin with that. Okay. Now, however, my question, so was that clear? Now, but my question really was, why would it now be valid? You have a law about climate change, and the legislation is affecting farming and agriculture, which obviously are exclusive subject matters belonging to the state parliaments. So that's my question there.
Yeah, is it because it has to be proportionate and adaptable?
No.
To what?
Can somebody?
I don't know.
Try to answer the question.
Scott, well, perhaps I could. You could, by applying the principles of the Boilermakers case, you could say that agriculture and
Boilermakers. Which case was that? Not Boilermakers.
Boilermakers case. So
not Boilermakers. Which case?
Engineers case.
Engineers case. Yes. So trade and commerce. It would be associated, farming and agriculture practices are associated with trade and commerce within the countries and other states. You know, that's why they're doing farming and agriculture. It'd be on-sold either with interstate or international, and therefore the Commonwealth can extend their powers to cover farming and agriculture based on their case.
Very good. So that answer has to be there as well. In other words, it is not sufficient to just say that this is valid on the basis of the external affairs power. Because, as we said, there is a problem because it doesn't relate to climate change. So you need to make an argument that following the engineer's case, following the expansionary doctrine and consequences of the engineer's case, and the case of Actors and Announcers Equity Association versus Fontana Films Proprietary Limited, this law is valid even if it is not directly related to the treaty provisions. Thank you, Scott. And thank you, Olowayumi. Okay, final question. In 2013, the Commonwealth Parliament passed the Money Laundering Act Commonwealth to implement the International Convention Against Money Laundering, a multilateral treaty that Australia ratified the year before. One of the provisions of the act required Australian employers to provide new and further benefits to their employees. XYZ Proprietary Limited, an agricultural company in Queensland, seeks to challenge the act for being beyond the legislative powers of the Commonwealth Parliament. Advise XYZ Proprietary Limited on whether its legal challenge is likely to fail or prosper. Comments? Answers? Volunteers? And I must say, I'm really happy with the quality of the answers in tonight's tutorial. It's apparent to me that, you know, you've really understood constitutional law. Well done. Okay, any answer to this specific question?
Can I just try with the issues? I think I'm still having problem getting the issue right. So is this provision of the Act to provide new and further benefits to employees a valid provision that can be validly included in this Money Laundering Act? Is that specific enough? No.
Too specific. I couldn't see the head of power there.
Okay.
Don't speak about the provision. Just say this specific legislation.
All right. It validly constituted under Section 5129 of the External Powers Act.
Yeah. Is it valid under? Can it be? Is it valid under Section 5129?
Of the Constitution.
Very good. Yes.
I don't know. The one I have just briefly is that this power is not unlimited, and the High Court recognizes three broad restrictions on the Commonwealth's power to implement treaty obligations. A treaty must be a bona fide international agreement. It must be reasonably related to the treaty. Airlines of New South Wales and New South Wales. The treaty power is limited by other aspects of the Constitution, such as the implied right to political communication and guarantees contained in Sections 116, religious freedom, and Section 92, free trade within the Commonwealth. And the provision that requires employees to provide new and further benefits to the employees does not appear to have anything to do with money laundering or the purpose of the treaty, and thus can be challenged on the grounds that the provisions are inappropriate and not adapted to the ends of the treaty.
So you're saying that this treaty, this specific law would be invalid? Okay. What do others think? Nicholas, you're saying could it be considered under the international relations power?
Oh, sorry, industrial relations power.
Relations power, okay.
So take it out of the international sphere, and then I think the argument just falls over there. But
so in that case, what would you be saying, Nicholas?
So I'd be asking whether the issue is whether the Commonwealth can legislate on the relationships between employers and employees under industrial relations power.
Very good. I'll get back to that. Tiffany, raise your hand. Tiffany?
Hi, yeah, I just wanted to ask, it might sound like a really stupid question, but when it comes to like all this legislation and how we're putting it under the different heads of power, when the Parliament actually passes this legislation, in the legislation, do they have to state the head of power, or is this only an issue once it comes before the courts?
Only once it comes before the court.
Okay, once it comes before the court, then they've got to try and scramble and say what one they intended for it to be under. Is that right?
It means that the Attorney General has to justify the validity of that law. There is no requirement on the part of the Commonwealth Parliament to actually state that this law is valid on the basis of whatever. There is no requirement for that. Although the reason why the Commonwealth Parliament is passing that legislation will likely be contained in its transcripts and in its proceedings. But there is no requirement. But if it were to be questioned, then obviously the Attorney General will have to justify that specific legislation on one of the heads of power of the Commonwealth Parliament. But what Nicholas pointed out is crucial, and that is that when you're confronted with a question such as this, what you need to do then is to justify the validity of that law among different heads of power. So you probably argue on the basis of external affairs power, you'd argue on the basis of industrial relations, you'd probably argue on the basis of international commerce. And if the law can be validated on any of these heads of power, it will be a valid law. And so I say that, B, because I don't agree that this is an invalid law. This should be a valid law. And either on the basis of any of those three heads of power because of the expansionary consequences of the engineer's case. I would argue that this is a valid law. But you are correct when you cited that the powers of the Commonwealth Parliament obviously are not unlimited because they are controlled and limited by constitutional rights and freedoms. They're also controlled and limited by the separation of powers. And they're also, especially in relation to the issues of defense, there will always be a question of purposiveness and a question of reasonableness and proportionality. But what we need to remember is that if the Commonwealth Parliament can cite a head of power on which it can legislate on a specific subject, following the engineer's case, it is likely to be valid if there is a sufficient connection. If there is a connection between a head of power and the legislation. And in this case, you can actually cite three. International relations, you can cite industrial relations, and you can cite international commerce. Tiffany raised her hand. Yes.
Sorry, so just on that point, if we were to get, say, a problem question and it was that somebody was, like this, challenging the law and saying that it wasn't valid under, 51.29 in our that's my notes, 51 subsection 29, if we were to then go in and argue, well, that doesn't matter because it's valid under one of these other heads, that's still a right answer.
It would be a right answer, but the high distinction answer would be one that is able to cite other heads of power that can be used to justify that legislation. So in other words, if all you do is cite international relations and you ignore the possibility that you could argue the legality of this law on the basis, for example, of international commerce as well as industrial relations, or even about, trade businesses in Australia, then you're missing a crucial component that would justify the validity of this law. So an HD answer would be able to spot all these various heads of power on which could rest the validity of this specific legislation. So the answer would be that this is a valid law, both because you can cite a head of power to justify the reason why the Commonwealth Parliament can pass that law, and on the basis of the expansionary consequences of the engineer's case. The High Court is likely to recognize the validity of this law, even if it does not directly relate to money laundering. Comments?
So, yeah, I think the money laundering bit then tends to be a bit of a red herring, isn't it? Because it says they pass this act in order to implement this convention, but then actually, this industrial relations has nothing to do with that. So they are able to put provisions in a Money Laundering Act that actually have nothing to do with money laundering?
It's difficult to say that it has nothing to do with money laundering. The argument that can be made here is actually that when in relation to, I'm just finding it funny, really, that's how expansive the power of the Commonwealth Parliament is. It can actually be argued that on the basis of the Money Laundering Act, one of its key provisions actually has affects, employee benefits. So you can argue that on the basis of the requirement about money laundering, it needs to be able to control whatever benefits are given to employees. And there is no requirement that there has to be a direct, as stated in the case of the Tasmania Dam case, as well as obviously in the engineer's case, there is no requirement of a direct connection between the treaty and a legislation. There is no requirement of a direct connection.
Manjo, but doesn't there, Scott Wellburn, but doesn't there have to be a reasonable proportionality between the purpose or object and the means of the law? Only if you're
invoking the defense power of the Commonwealth. There is no such requirement in other legislation. Only if you're invoking the defense power and if it interferes with the rights and freedoms of individuals.
Oh, right. I thought that was found. I thought that's what the Tasmanian Dam case found for the treaty power.
Not exactly. In fact, that is in fact what I think, if I remember correctly, Justice Mason said. And I'm quoting here what he said: "There is no persuasive reason for thinking that the international character of the subject matter or the existence of international concern is confined to that part of a treaty which imposes an obligation on Australia." So it can be beyond the scope of Australia's obligations under a treaty.
Yeah, that's what Mason said. I just get confused because Justice Dean went further to say that implicit in the requirement that a law be capable of being reasonably considered to be appropriate and adapted to achieving what it is said to provide it with the character of a law with respect to external affairs is a need for there to be reasonable proportionality between the designated purpose or object and the means which the law embodies for achieving or procuring it.
That's right. So what we need to examine, therefore, is what exactly is the position of the High Court, because it's possible that there are dissents within the High Court. And at the end of the day, the question really is, what is the rule of the majority? And in this particular case, Chief Justice Mason is on the side of the majority. So you can certainly make an argument on the basis of a dissent by a justice.
Yeah, sorry, I didn't realise Justice Dean was in dissent. My mistake, sorry.
No, that's fine.
No, I think we are all just a little bit, just come to the realization that none of us are actually paying any attention to the details of all these new laws that are being passed, that they could actually put into a law about something totally provisions that you don't realize affect your life. It might affect you when you think from the title and the purpose of the act. It shouldn't have nothing to do with you see?
Yeah, but
unless it's tax.
We just have to remember is that the High Court is really unlikely to shoot down a Commonwealth Parliament easily. It's unlikely as a general rule, because for as long as given the fact that we have the engineer's case, what is likely going to happen is that the High Court will validate a law for as long as there is a head of power on which the Commonwealth Parliament can base its legislation on. Chances are it will shoot down a legislation if it clearly goes against certain rights and freedoms. In that case, you have to apply the purposive test or issues about reasonableness and proportionality. But otherwise, the High Court, especially the case of the engineer's case and the case of the Fontana actors and equity guilt case, that what the High Court do is to give a very liberal interpretation of the wide powers of the Commonwealth Parliament.
I think one of the key legislations where they can't mix laws is in regards to tax. So if
Yes,
it's
that's
a
right.
tax law, it can only be tax, it couldn't be.
That is correct. Very good. That's right, because there is a constitutional prohibition against that, against tacking. Very good. Okay, so I think it's 7:17. It was a fantastic discussion we had tonight. I'm glad, fantastic contributions from all of you. So thank you, and so it's week 10. We have one final tutorial next week in relation to one of the topics. Then we're going to have a tutorial in week 12 where we're going to have a revision, as well as some guidance I will provide on how to identify the issue, because I think that is something we need to work on still. But for tonight, I thank you for your participation, and I hope to see you again next week. Good night, everyone.